So I'd like to welcome everyone that's logged on with us today. Our session will be led by Stacey Sarver, and she will be addressing legal resources from her organization, Women's Law. Stacey Sarver is the legal director of womenslaw.org, a project of National Network to End Domestic Violence, and is the senior attorney for NNEDV. Prior to joining Women's Law Org in 2007, Ms. Sarver worked at a nonprofit organization in New York City representing low-income domestic violence victims in family court. She graduated cum laude from Fordham Law School in 2003. And during this session, I just want to let everyone know that you can type questions or comments into the thin white strip below and click send to submit. And you can exit this session at any time by closing out of the window completely. I'd also like to say that presenting this speaker does not imply endorsement by our organization. This speaker's comments and opinions are her own. Friends Health Connection does not control the content of the webinars and is not responsible for the content presented. This event is not intended to constitute or replace medical advice, and appropriate medical advice should always be sought by your own medical professional. I'd also like to thank you, Stacey, for joining us today and everything that you do.
Thank you, John. Okay. So thank you for joining us today. As Callan said, my name is Stacey Sarver, and I am the legal director at womenslaw.org. Women's Law is a project of the National Network to End Domestic Violence. And what we do at Women's Law is that we have a website that talks about legal information and non-legal information for victims of domestic violence. And our goal is to make the laws understandable to everyone. And so we try to present the information in what we call a plain language format, and it's in a question and answer format. And so at any time, someone can log on and look up the laws for their state. And our website, which is www.womenslaw.org, is something I hope some of you might be able to utilize in the future. And periodically throughout this presentation, I will be referring to it. I have some pages from it in the PowerPoint that are relevant to the discussion. So today I'm going to talk about possible legal remedies to deal with domestic violence. And I welcome any questions. As Callan said, you can type them in, and then at the end, I will try to answer them all. I'm not going to be giving out any type of specific legal advice, but if you have general questions, I'd be happy to try to answer them. So as many of you may know, domestic violence comes in many forms, the most obvious form being physical abuse. However, there's many other forms of abuse. Let's take a look at slide number 1 on the PowerPoint. And this is a snapshot from our website, womenslaw.org. And as you see, the tab that's pulled down on top is called Learn About Abuse. And we have various pages regarding different forms of abuse. So the first one is, you may be able to see, I know that PowerPoint is pretty small from your vision, but it's a checklist of am I being abused with different signals, signs of abuse. And we have domestic violence, emotional abuse, sexual abuse, partner marital rape, and all different forms. And so anyone can go on and look through and see if they're not sure if what they're experiencing is domestic abuse. This is a way for them to go on the website and read through and try to make a decision for themselves. Now, one of the very common forms of domestic abuse or domestic violence is what's referred to, let's go to slide 2, as emotional abuse. It's often called verbal abuse or psychological abuse. And basically, it deals with mostly language, so constant criticism, let's say criticizing your intelligence or your looks, your parenting abilities, damaging your relationship with your children, telling you that you're crazy or calling you different names. These are all forms of verbal abuse, or could be, I should say. And additionally, sometimes threats or fear, causing fear by intimidation. These are all different forms of abuse, and we talk about them on our website. Now, the reason why I mention that, the reason why I want to highlight this and the different forms of abuse in this presentation is because not all forms of abuse are illegal per se. And so there's not necessarily going to be a criminal law against calling someone a name or telling someone they're crazy. And there's a fine line between, in that respect, between freedom of speech and between when something becomes a crime. The laws are different in every state, and criminal laws are generally the ones that apply here are state specific. Let's take a quick look at slide number 3, which is another snapshot of our website. And the tab that's brought down is the one all the way to the right that says legal statutes. And the one I have open now is Nebraska. And if anyone logs on, they can click on their state in the drop-down menu and change it from Nebraska to any other state. And they can log on and see a snapshot of different criminal laws. We don't have everyone listed, of course, but we do have various laws dealing with stalking, harassment, threats, things of that nature. And so that's a good first step, at least, to take a look at the language of some of the laws, some of the criminal laws, to see if anything that you're experiencing or someone you're working with, if you're an advocate or a social worker or something of that nature, fits into one of these definitions, perhaps, of actually having a crime committed against him or her. But just because it may not be illegal per se, it doesn't mean that there's nothing that can be done about it. And so in this presentation, I'm going to talk about 2 possible ways of dealing with domestic violence through the justice system. One is through the civil law system, civil justice system, and secondly, through the criminal justice system. So the first one I'm going to talk about, as I said, is handling domestic violence in the civil justice system. One of the main resources in that regard is applying for what's called a restraining order. A restraining order can be called by many names in different states. In New York, where I'm from, it's referred to as an order of protection. In some other states, it's called an injunction against abuse or protection from abuse order or a protective order, protection order. There's many different names that it can go by. But the basic gist of it is a restraining order is an order, a civil order that is signed by a judge that restrains or prohibits someone from doing certain behaviors. And we'll talk more later on about possible remedies from a restraining order or an order of protection. For the most part, restraining orders, well, when they deal with domestic violence, are free and free to file for it, free to have it served. Generally, law enforcement in the state will be in charge of serving it. The victim herself may have to bring it to law enforcement or may have to confirm that it was served, get the affidavit of service back from law enforcement. But generally, serving the order, there's supposed to be no charge for that. And when a person goes and files for the order in court, first of all, every state may have different rules about this. In some states, a person can only file during certain times or certain hours of the day or certain days of the week. This was new to me because where I used to practice in New York City, you can go in at any time in the day and file for it when the court is in, or even in some courts we had night court. But I've come to learn that through my work at womenslaw.org that in many states this is not the case. When a person does go in, oftentimes a judge will issue what's called an ex parte temporary order. Ex parte is Latin term, basically meaning from one side. And what an ex parte order does is, well, first of all, it can be given without the abuser present and without prior notice to the abuser. So he or she does not have to be notified beforehand that an order is going to be taken out. And the ex parte order can be issued that same day and given to the person, the victim, as she's leaving or he's leaving the courthouse. And usually it's effective once it's served. So the quicker it's served upon the abuser, the quicker it becomes effective and a valid, effective order. Usually, no arrest or police report or police involvement is needed in order to get this. The civil system is separate from the criminal justice system, and so generally, a lot of times people write into womenslaw.org. We have an email hotline, and they will ask us, I want to get a protection order, but I've never called the police. I don't have any proof. And one of the things that we point out is that oftentimes proof, quote unquote, could be a person's testimony. Credible testimony can go a long way towards getting a protection order. So even if there's no police reports or police involvement, that's not necessary for filing for a civil restraining order. Now, the 2 major facets a person needs to look at when deciding if she or he is eligible for a restraining order are the grounds, so basically the reason You have to be able to prove the definition of domestic violence for that state, as well as the relationship requirement. You have to meet certain relationship requirement from the state in order to apply for a restraining order or domestic violence protection order. So let's take a look at slide number 4. This is a sample. Again, I'm sorry if you can't see the text. I didn't realize it was going to appear smaller. But this is a sample from our website of a state. This is Colorado. And in every state, we have a question about what is the legal definition of domestic violence. And so that's for how domestic violence is defined in that state for the purposes of getting a restraining order. And so in Colorado, domestic violence for this purpose is defined as any act of violence or threatened act of violence against you, your children under 18, and any animal owned by either of the parties or a child by either of the parties. And then we go on to give some examples of behavior that might qualify as domestic abuse, such as name calling, threatening or harassing phone calls, when the abuser threatens to injure himself or herself, and there's many more. But in other words, in order to even be able to apply, a person has to allege one of these grounds of domestic violence. So, and then let's go to slide number 5, which talks about the second facet, the relationship requirement. And this is a snippet from California. And again, in every state, we have a question, am I eligible to file for a restraining order? Or in this case, it's called the abbreviated a DVRO, domestic violence restraining order. And so in California, a person has to have the relationship of a spouse or former spouse, a person you're dating or used to date, including a same-sex partner, the mother or father of your child, a person related to you by blood, marriage, or adoption, or a person who regularly lives or used to live in your home. Generally, this is often termed a family or household member. You may see that a lot on perhaps a petition or in something that you're reading about your state. And each state will have a specific definition of what a family or household member is. Some states allow you to file against anyone living in your home, even if it's not an intimate partner, whereas other states do not allow that. So this is going to be something to explore when you're applying for a restraining order, whether or not you meet the grounds and the relationship requirement. And of course, that's not to say a person is guaranteed to get the order. He or she still has to prove the allegations in the petition, and the other party has a chance to refute them, but we'll get into that a little bit more later. The beauty of a civil restraining order is that it can criminalize behavior that is not otherwise illegal. So let me say that again. A restraining order can take regular everyday behavior, such as walking by your house, calling you on the phone to say, I love you, I miss you, showing up at your child's school, can take regular everyday behavior that is not illegal and make it illegal. So a restraining order can order someone to stay away from your home, from you, from your child's school, not to have any contact with you, regardless of if the contact is threatening or if the contact is to say, I love you and I miss you. If those things are prohibited in a restraining order, and all of those actions can be violations of the order and can be criminal behavior, criminal activity, and a person can be arrested for that. And the other remedies from a restraining order, there can be many of them, but the main ones I want to focus on is that a restraining order can exclude somebody from the home. If you're living with your partner and your partner is abusive, in many states, even if your partner is the sole owner of the home, so perhaps he or she has the title to the home, you just moved in there a few years ago, but you've been living there, a judge can still exclude the person, the owner, the respondent from the home for a period of time of the restraining order. The judge can also order that you have possession of the car, can order the other side to continue to make mortgage payments perhaps if it's a you're both living in, and if you're married, support your children to get temporary child support, temporary custody. There's a lot of remedies. But the ones that I've just mentioned about exclusive use of the home, so excluding someone else from the home or giving you use of the car or other personal property, that's going to be dealing with possession or use of the items, and it's not going to go towards ownership or title. So it does not affect who actually owns the home, but it affects who can possess or use the home for the period of time of the restraining order. Now let's go to slide number 6 and just take a look at another question on our website, which is, again, in every state we have this question: how can an order of protection help me? And this is state Arizona that we have here. So in the state, an order of protection can order the abuser to not commit any of the offenses included as domestic violence. So an order can say, do not harass, abuse, assault, menace. It can list a litany of crimes and tell the person not to do those, which of course a person should know anyway because they're crimes, but again, it can order them not to commit those crimes. It can order the person to have no contact with you of any sort, including texting, phone calls, letters, third-party contact, which basically means if, let's say, the abuser calls his sister and says, hey, can you call her and ask her this, the victim, that could be prohibited as well. In this state, the order can make the abuser move out if you live together, can order him or her to turn in any firearms in his or her possession, not have contact with your children. And this is one that has been added to almost every state over the past couple years, I've noticed, can order the abuser to stay away from an animal owned by you, by the abuser, or by a minor child of either, and can order the abuser not to harm the animal. I see a couple of typos on this page that I will fix. In this state, the order will not decide issues of child custody, visitation, or support. And it says it will not divide jointly owned property. In some states, you very well can get temporary child custody, visitation, or support through an order of protection. So again, it's going to vary from state to state. Another thing that varies in terms of the order of protection is the duration, the length of the order. Some orders, a final order can only be issued for 6 months. In some states, it's a year, 2 years, 5 years. At least one state I know of, it's permanent. And so it could last forever until the abuser makes a motion in court to try to undo the order. So again, this is going to vary. I will also have this on womenslaw.org for each state about the length of the order. And the general process can vary as well. So in many states, the victim applies at first for and gets an ex parte, immediate temporary order that day. And then there's a hearing set down for a final order, where she has to prove basically the allegations committed, and there could be a hearing, which is like a trial with lawyers and witnesses and documents and testimony and etc. And this could be in 10 days, in 2 weeks, or in many months, or it could take upwards of a year. In New York City, where I practiced, oftentimes cases were adjourned. Is not uncommon to be adjourned every month for a year and before you have your final hearing. And the ex parte ordered temporary orders generally continued for each court date. And the length, as I said, the length of the order is going to vary between states as well. So that's something to be aware of, how long the order is and whether or not you can extend the order without any future allegations of abuse. In many states, you can extend the order whether or not anything happens during the length of the order. Now, in order for a protection order to have value, we have to look at the enforcement of the order. So if the petitioner is not going to enforce the order, meaning report violations and have the abuser punished for violations, then the order is not necessarily worth much. I mean, yes, it might scare away an abuser to scare him or her to stop acting in a certain way, but if he or she knows that committing any of the acts prohibited, nothing's going to happen, there's an argument to be made that it's not really going to be helpful to have this type of protection order if the victim is not going to enforce it. And there's 2 main ways to enforce a civil order of protection. So through the civil system and the criminal system. Generally, enforcing it through the civil system means that a person would file a motion for contempt or violation petition. Again, it's going to vary between states, so I'm speaking very generally, but there's going to be some type of motion or petition that's filed in court in which the person is telling the judge, hey, listen, this abuser did not listen to your order. He or she violated the order, called me, came to my home, etc. And you're asking for contempt, that the abuser be held in contempt of court, and that there be punishments, which again varies between states, but could be fines, could be jail time, could be lengthening the order, let's say, extending the order or adding more provisions. That could be a remedy of going to court for a violation of the order. So it really is going to depend on the state and on the judge and on the specific situation. The other way to enforce the order is through the criminal system. And this involves going to the police, going to law enforcement, sheriff, wherever it is in your county, that whoever it is that is a law enforcement officer, and reporting a violation, and the person could be arrested and be prosecuted by the district attorney or the county prosecutor, whatever the terminology is in your state, and can go through the whole criminal justice system for violating the order. And he or she can be arrested and charged not only with contempt, so like criminal contempt of the order, so going against the judge's order, but also can be charged with whatever crime may have been committed while violating the order. So perhaps if the person just called you and said, "I love you," that's not necessarily a crime, except for it's against the order of protection. So in that sense, it is a crime. But if, let's say, the person came to your home and broke into your home and stole something or threatened you with a knife, that could be another crime in and of itself, and the person can be arrested for that crime as well. Okay, so that's in sum the first part of the presentation, where we talk about handling domestic violence in the civil justice system. So now I'm going to go on to talk briefly about handling domestic violence in the criminal justice system. And so generally this begins with a report to the police. As I said, a report to law enforcement. This is assuming there's no order of protection, just someone has been abused, what can they do? So a report to the police is made, and then a possible arrest. The police could come and investigate, and the person can be arrested or could not be arrested. And you have to plan for both scenarios. So oftentimes a victim may be afraid to call the police because she's afraid that the abuser will not be arrested. And now the abuser will know that he or she has called the police, and perhaps there might be even in more danger. So this is something to hopefully think through and plan with an advocate as to whether or not, what a plan would be if an incident of abuse happens, if you believe that you're being abused. So after a possible arrest, generally in most states, I would say that a restraining order could be issued routinely. So it could be issued at arraignment, which is the formal bringing of the charges against a person. That's oftentimes where the order of protection can be issued, or it can be issued at the first court date, where the abuser is represented by an attorney and brought back to court. And so something interesting about a criminal protection order is that oftentimes the victim may be unaware that the criminal protection or restraining order was issued. Because unlike civil court, the victim is not necessarily going to be in court for the criminal court dates, unless he or she is subpoenaed to testify about at a certain trial or hearing. But oftentimes the victim may be unaware that a protection order was issued. It might be sent to her in the mail. So there may 3-4 days might go by where a protection order was issued and is valid, and the victim actually is unaware that one exists and is not enforcing it. So it's important if you're not if you're being arrested, it's important if the abuser is being arrested to be in contact with the district attorney who's handling the case and to say, hey, was there an order of protection issued? If so, can I please get a copy immediately? And if one was not issued, can one be issued as soon as possible if that's what the victim wants? Now the other difference between a criminal and a civil restraining order is that in a criminal order, the victim is not a party to the case, and so she's not in control of the order. In the civil restraining order arena, in the civil justice system, the petitioner usually is the victim. So the victim the victim is usually a party. She's the one petitioning for the order of protection. And so it's a little bit different, because if she then wants to try to modify the order or even dismiss the order, she can file in court and ask the judge to do that, and then it will be up to the judge to decide. But in the criminal justice system, it's a district attorney generally who's asking for the order and the judge who's issuing it. And the victim's wants and desires regarding the order, whether one exists or one should not exist, may not be heeded. And so that's sometimes difficult for people, of course, to understand, hey, I want to get back with this abuser, but there's a restraining order and I don't want it there. How can I undo this restraining order? And we get this question a lot on our womenslaw.org email hotline. And one of the things that we talk about is, how in a criminal case, as I said, the victim is not a party to the case. And so she may not be able to have the order dropped. She may be able to express her desires to the district attorney and explain perhaps why she feels no order is needed, but it's going to be up to ultimately the judge, but it'll be up to the district attorney generally to present to the judge, okay, we're asking to dismiss the order or modify the order. Again, this could be different in each state, and some states have victim advocates who are very involved, victim advocates as part of the district attorney's office, and so there may be a different procedure or different avenues that can be taken, but generally she may not be in charge of whether the order continues or is dropped. Similarly, with criminal charges, oftentimes the victim is not in charge of whether the prosecutor proceeds with charges against the abuser or not. Many states have victimless prosecution policies in which even if the victim is not cooperating, they can continue with the case anyway. There's other evidence. There could be 911 calls. There could be doctor's records, doctor's testimony, witnesses, things of that nature. So she may not be in control of whether she can press charges either. And if any of you work with victims who are going through the criminal justice system, you may hear what I often used to hear when I was their civil family law attorney is people referring to the district attorney as my lawyer. They'd say, oh, I have my criminal case today. I have to go meet with my lawyer, and my lawyer is going to get me my protection order. And this is a misnomer because the DA is not the victim's lawyer per se. The DA represents the state, and the victim as a member, a constituent of the state is, I guess, his or her interests are represented in that sense, but the DA is not a zealous advocate's wishes as a civil attorney would be. And so if ever you hear someone talking about this, it may be valid point to mention that the district attorney actually is not the victim's lawyer, but is supposed to be representing the victim's interest in a sense. Lastly, sorry about that. I think someone's calling on my call waiting and it's making noise. So depending on the situation, another avenue to explore is safety planning. And safety planning is something that can be done on one's own or with a domestic violence advocate through an organization. Let's take a look at the last slide. That's slide number 7. And on womenslaw.org, you can't see the tabs, I realize, up top, but on the very first tab, all the way to the left, we have a tab called Safety Planning. And these are the different sections that it's divided into. So there's one called Internet Security, which is general safety tips for emailing and browsing the internet. And then there's safety planning for different stages of an abusive relationship. There's one called Safety with an Abuser while you're still together. There's one called Getting Ready to Leave. One called Ending the Abusive Relationship, and another called Safety in Rural Areas, Safety Tips for Stalking Victims. So anyway, we have a lot of this information on womenslaw.org. But if you are working with a victim or if you are a victim yourself, one thing to really think through when you're safety planning is the best way to pursue remedies to deal with domestic violence. Is it civil? Is it criminal? Is it both? Or is it neither? And so each person's going to have to decide for themselves what is the safest thing for them to do in their situation. And so that concludes my part of the presentation. And I'm going to look now at some questions that came in. So somebody asked us, where is our organization? Our organization, womenslaw.org, we're in Brooklyn, New York. But the main organization that we come from, which is called the National Network to End Domestic Violence, is in Washington, D.C. But what we do at Women's Law is we don't actually do direct service. And so all the services that we give are the information on our website and the email hotline, which we run. And our email hotline is on our website. We have a button to the right called Ask a Question. And a person can click on that and can email us a question, and it will be answered within 3 to 5 business days. So it's not an immediate hotline in the sense of calls and there's 24-hour staff, but it's more for someone has a question they want to ask about their situation, or they don't understand the law in their state, and so they can email us. So at times we have to close the hotline. I believe it's closed right now until tomorrow, but that is available 24 hours a day, and it's answered every day, even on weekends. And then someone's asking, can we meet with a person from women's law in our own state? And so hopefully my last answer answers that question, but unfortunately we don't have any in-person consultations. The only consultations we do are through, well, they're not really consultations, but the only interaction I guess we have with individual people are through our email hotline. And so that's something that someone can write in and ask us a question. And so I'm going to wait one more minute and see if there's any other questions. And if not, I am going to thank you for coming to this presentation. And I hope you got a little bit of a better sense of the different remedies through the civil legal system and through the criminal legal system dealing with domestic violence and domestic abuse. Okay, so Carolyn, I'm going to log off and thank you all for coming.